So then, okay. Good evening to you all. Welcome to this event dedicated to the reflection of European objectives and specifically dedicated to the states aspiring to join the European Union and in particular Kosovo. In the history of Western law, codification continues to be presented as the culmination of a long process of rationalization, having led the perfection of a systematic organizational social relations. A code, as a formal device, constitutes the ordering of the technique of order that is the law. Its deployment within the rational reading of the world, which the systematics of the code is supposed to allow. In order to make the leap from fact to law, there must be a mode of representation that accepts both the distance from factual reality and the formal adequacy with its mode of operation. As such, the law remains powerless to propose such a mode of representation as itself. Its desire of order is still the register of the appeal or the wish. But with a code, rhetoric becomes aesthetic. The stylistics of the law are transformed into the machinery of perception. It sounds very important today because the COVID-19 pandemic has plunged Europe to the worst economic crisis it has since 1945. The restrictions imposed in public life in the wake of the pandemic have shown us how much as we, EU citizens, are dependent on the common internal market and the border-free Schengen area and how much we benefit from them on a daily basis. Unfortunately, the crisis has also shown us the fragility of our mutual trust and cooperation. At the same time, crises also offer unique opportunities to adapt to changing realities and be better prepared for global challenges. That's why we must use this crisis as an opportunity to enhance the competitiveness, resilience, and strategic independence. This achievement still has considerable shortcomings in its acquis communautaire. I know we'll talk heavily about it. Therefore, we must work together to identify gaps and formulate concrete proposals to remedy the remaining shortcomings. The dialogue necessary to work on this together must be characterized by a high degree of inclusivity for all economic actors, legal specialists, and representatives of civil society. Only a reciprocal and interdisciplinary partnership can lay the foundations for a European law that will facilitate cross-border trade, that's a fact, further improve solidarity and trust between member states, promote economic activity, boost investment, and ultimately contribute to Europe's legal sovereignty and competitiveness. I'm aware such projects may seem ambitious. The current global situation, characterized by trade and economic conflicts and immense global competitive pressures, the EU must take its own place on the world stage and set exemplary standards based on cooperation and coordination, in particular with those who are aspiring to join the EU, and more again, with those who we share the same currency. That's why today I'm very pleased to welcome Dr. Julieta Plakoli-Kesumi. You are currently teaching business law, contract law, and intellectual property law. You're Vice Dean for International Relations and Student Projects at the Faculty of Law at the University of Pristina. You are also specialized in contract law and consumer protection. Thereafter, I'm very happy to welcome Dr. Cenk Belisha. That's it. You're currently teaching civil law, property law, and EU commercial law. You have been working at the University of Pristina since 2004. You have been a member of the drafting committees of the legislation and worked as a senior legal expert in EU, USAID, and projects in Kosovo. Let me please welcome then Korab Sejju, a lawyer, founding partner of the law firm Sejju and Chergini, also licensed to practice law in the United States, New York, New Jersey, and Pennsylvania. Arbitrator at the Alternative Dispute Resolution Center of the American Chamber of Commerce in Kosovo, former member of the Parliament of Kosovo, and you're currently teaching in the field of business law, corporate governance, and financial services law. You taught business law and international economic law at the Faculty of Law and University of Pristina. And finally, Arjen Recha, legal manager at Deloitte Kosovo, legal manager in tax and legal department. You hold an advanced master's degree in international and European economic law. You from the Faculty of Law of the University of Maastricht. Previously, you worked as a legal associate in a law firm and as a senior legal researcher at the Kosovo Judicial Council. And you can testify with 7 years of experience in corporate law. So, let me please before welcome Lidon Bayrami, diplomat at the Embassy of Kosovo here in Paris, who will be happy, I guess, to share with us his feelings at the end of this reflection. So let's open the discussion with Julieta Plakulikescu. Codification of European business law within the context of the EU enlargement process. Doctor, what does it mean for Kosovo today?
Thank you very much, and good evening, Paris, and good evening, Pristina. It's very good to be here today, although virtually, and address the audience. I would like to thank in particularly Ms. Bernard and all the colleagues at Europa Nova for taking up this initiative and for organizing this webinar on this very important subject for both the EU and the Western Balkan countries who aspire one day to become part of the greater European family. And a special thanks to our former student Fiol Ibrahimi for all her work in reaching out to us with this brilliant idea. And of course, thanks to my co-speakers from Kosovo who have kindly and without hesitance accepted to be here with us today and share their experience and perspective. So I would like to start my presentation with a general remark on the EU enlargement process and the progress made so far by the Republic of Kosovo, and then move on to the idea of the codification of the European business law within this context. As you know, Kosovo, together with other Western Balkan countries, have for many years now tried to pave their way towards the EU, although with numerous challenges. With the launching of the stabilization and association process, Western Balkan countries took up several obligations in addition to general criteria known as Copenhagen criteria, and have since been measured in the progress towards fulfillment of these obligations through annual assessment reports of the European Commission. So Kosovo is already on its path toward fulfilling its obligations for joining the EU. And although with the status of a potential candidate over the past years, it has undertaken extensive reforms in all areas, especially in the field of rule of law, as a fundamental precondition for EU membership and as a cornerstone of every democratic society. Because as we know, successful implementation of other criteria for EU accession depends on the successful implementation of the political criteria, namely the rule of law. So the government of Kosovo has pledged to move the country from a potential candidate to a candidate country, which will undoubtedly be a great leap forward. Unfortunately, this is not done as easy as said, because as you are aware, every progress of Kosovo on its European path depends on the progress of negotiations with Serbia rather than on the fulfillment of the actual criteria per se, and the formal one for the time being does not seem, unfortunately, promising. So notwithstanding this, Kosovo continues to optimistically believe in its European path and has approximated and continues to approximate its legislation with the EU acquis, thus ensuring that every piece of legislation passed in the Parliament of Kosovo respects the principles of European law, or at least does not contradict the EU legislation. So this is the case with the business legislation as well. And only a couple of years ago, Kosovo reformed its business law through further approximation with the EU acquis. The same was done with other relevant pieces of legislation, such as consumer protection, contract law, through the codification of the civil law, which is still under review and not enforced, intellectual property legislation, fiscal and tax legislation, and so on. There are, however, still several laws that still need to be harmonized, such as competition law, bankruptcy law, and other relevant laws that need to be reformed and brought in line with the European standards. And all these laws are important for the fulfillment of the economic criteria requiring a functioning market economy and the capacity to cope with the competition and market forces. Because as we know, functioning market economy means ensuring fair competition, fighting informal market, digitalizing the economy, protecting consumers, strengthening labor rights, providing sound fiscal policies, and so on. And to achieve all this, legal certainty is a key, which is only ensured through good, harmonized, and enforceable legislation. So Kosovo is still on the stage of approximation of its legislation with the EU acquis as a means of fulfillment of the accession criteria. And while we are still trying to catch up with Europe, we are witnessing that the EU has moved on with the idea of codification and consolidation of its legislation, and concrete steps as mentioned have been taken in this regard. So consequently, the first question to ask is whether Kosovo is ready to join the European discourse on the codification of the business law, having in mind also all the challenges that it faces with its undefined political status and the visa liberalization issue. And the second question is, what does the codification of EU business law mean exactly for Western Balkan countries in general and Kosovo in particular? Now, skeptics might argue and see this as not a good news, maybe, as it will entail a new harmonization process of national legislations of Western Balkan countries with a newly codified EU legislation, additional criteria and conditions in the never-ending list of conditions to be fulfilled in the context of EU accession. So, of course, codification is not a one-step process and will not happen overnight, but given the speed or lack thereof with which Western Balkan countries are making progress, it is very likely that the codification might become reality way before Kosovo joins the European Union. So current Kosovo status in the EU accession process and conditions it still must fulfill may make the concept of the codification of the EU business law for many somehow difficult to apprehend from where we stand today. In addition to this, in a digitalized post-pandemic business era, there might be additional skepticism regarding the codification of a fluid and dynamic area such as business law. Looking from another, more optimistic perspective, the idea of the codification of the European business law seems good for Western Balkan countries. Firstly, because the codification will replace fragmented rules and simplify the legislative framework for both EU and non-EU countries. So instead of harmonizing business and commercial legislation with several directives and regulations, one will have to look at only one code. So if the current, you can just imagine if the current fragmented laws and regulations in the field of business law are difficult to access and unclear for EU businesses and citizens, one can only imagine how difficult and complex they are for businesses and citizens of Western Balkan countries. Secondly, codification will enable the consolidation of vast laws and practices, and it will most probably also integrate case law of national courts which have often provided innovative solutions to complex legal issues. Next, codification will most probably require the creation of a specialized commercial court at the EU level. And Kosovo is close to establishing a specialized commercial court in Kosovo. So this is a very good momentum for Kosovo to carefully consider the long commercial court in the light of codification plans at the EU level and make sure that it will not end up as another failed experiment, but it will be indeed a specialized and functional court and will treat cases with speed and efficiency, because no matter how good the law is, it's useless if it cannot be enforced. So I see all this as an opportunity for Kosovo to strengthen the legal certainty, which is a precondition of direct foreign investments and regional and international trade. And I truly hope that Western Balkan countries and their citizens will be consulted and called upon to provide the expertise in this endeavor. So it is very important that businesses, citizens, and professionals from Western Balkan countries are seen as part of this project from the very beginning. And I'm glad to see that today's event is an attestation of that approach. So with this, I would like to conclude my speech for now, and I remain open to any further discussions that we might have. So thank you very much for your attention.
Very interesting. Thank you very much. I think we'll have a lot of questions at the end of the reflection, but I know in order to focus a little bit more on business law, Çetin Berisha, which could be the way forward to more harmonized legal framework with the EU acquis?
Thank you. It is my pleasure to participate at this joint event organized by University of Pristina Faculty of Law and Europa Nova. I think it is good that we have at least this opportunity to share our ideas virtually, taking into consideration this impact of COVID pandemic to all of our lives. Well, the topic of codification of European business law, itself it's very interesting, and I think it's a good opportunity for all countries aspiring European Union, and in particular for the Western Balkan countries, which are doing a lot of efforts to harmonize, well, to approximate, and some of them even harmonize their legislation in light of European Union best practices. Although the codification of business law at this stage is seen more as an opportunity rather than a clear legal approach for the, from the side of European institutions, still I think the idea is very important for countries in the region, because we may have an early stage information, and we may direct our policies towards a future codification of business law. As we have seen from the past examples, definitely the process of codification in all areas of law, especially within the European Union, was really complex. For example, you know that the process of drafting a European Civil Code started like 40 years ago, and a lot of efforts have been made by experts in order to prepare firstly a draft common frame of reference, and later on, it was supposed to go through a process of drafting a civil code. However, this process was seen very complex in terms of having joint efforts from all member countries of the European Union. However, I think in the area of business law, there are greater chances For a successful process, taking into consideration the fact that it is related to internal market and freedoms, which are the key or the core concept of the European Union. But still, as my colleague Lilieta said before, this will be definitely a long process, and it should be seen as a good opportunity not only for the European Union countries, but for the Western Balkan countries, which are aspiring to the European Union as well. Well, the codification itself, it's not an easy task, even when it comes to codifying national legislation. For example, Kosovo is under an ongoing process of drafting a civil code, for example, for more than 7 years. And although we have already in place most of rules covering the area of the civil code, the process of codification was challenging in this case as well. We have had an idea as well of a commercial code of Kosovo, which is still at the stage of an idea from the Ministry of Justice. But I think this will even take more time to prepare or to come to a stage of having a draft of commercial code. However, I think that the process of codification of the European business law as such shall be seen as a tool for a better deepening of the European integration process. First of all, for the member countries itself, whose legislation in the area of business law is still facing divergences, of course having direct impact in the internal market. But on the other side, codification shall be seen also as a tool for better and easy implementation of legislation and improving the business environment. Of course, this process shall be used by candidate countries, mostly Western Balkan countries, and those aspiring, including Kosovo, to improve and further harmonize their legislation in the field of business law with acquis, and at the same time analyze and prepare for an informed decision-making process if such process of codification of the business law proceeds, if this initiative will further proceed in terms of European Union institutions. Coming back to Kosovo, although it is not obliged to fully harmonize its legal framework at this stage of the European integration process, as my colleague Lilieta already mentioned, some good progress and achievements happened so far, especially in regard to developing legal framework covering the area of business law. So far, the only contractual obligation that Kosovo has with the European Union is Stabilization Association Agreement of 2016. I mean, entered into force in 2016, and it is the main legally binding document between Kosovo and the European Union. A lot of references under this agreement are related to business law, including requirement to harmonize legislation and practices, as well as setting mutual obligations towards both European Union on the one side and the Kosovo government on the other side, related to the business sector. For example, the Stabilization Association Agreement provides a lot of references and regarding these references obligations to, for example, the issues of establishment, supply of services and capital, for example, Article 50 of Stabilization and Association Agreement, which provides also good definition what is meant by establishment. And in this regard, the establishment means the right to take up economic activities by means of setting up companies, including subsidiaries and branches in Kosovo and the European Union, respectively. For the companies from Kosovo and countries in Kosovo. On the other side, if we see Article 51, paragraph 2 of this agreement, it is clear that the European Union and Kosovo, with regard to establishment of companies, subsidiaries, and branches, undertake to treat them favorably and with no discrimination with regard to their businesses. Other provisions also related to commercial property, the right to own real estate, as well as renting and all things are addressed in different provisions of the Stabilization Association Agreement. Issues related to freedom of movement, especially from the Kosovo side, since we are not free to move, as we don't have a free visa regime with the European Union, are definitely harming implementation of some of the provisions related to establishment, to not only of companies but branches and subsidiaries from the Kosovo side towards the European Union. Of course, there are other issues from the perspective of Kosovo, which needs to be addressed in our national legislation. In particular, with regard to law and business organization, but other legislation as well. For example, currently, several challenges have been identified under the provisions of the law and business organization. For example, strict rules on composition of board of directors. I don't know where it came from, but law or law and business organization requires that each joint stock company, for example, have equal representation, gender representation in the board of directors, which was considered as a burden for most of businesses during this period from 2016 to now. Then other issues related to minimum funding capital are seen as non harmonized with EU acquis, because European Union legislation requires to have a minimum capital for limited liability companies, while in Kosovo we have removed any obligation from our legislation with regard to minimum capital, and it is seen as necessary because we are facing challenges in terms of defining rights and obligations of shareholders at this type of companies. Then issues related to merging of companies belonging to the same jurisdictions, and as well cross-border merging are seen as non-harmonized with the European Union acquis. Therefore, several provisions in our legislation require changes and harmonization with European Union directives, especially with EU Directive 2017/1132, including amendments to this directive, and mostly related to disclosure of information about companies in business registers, holding capital, divisions of companies, mergers within one country, and cross-border mergers. These are only some of the issues that that require addressing under our legislation, but there are many other issues that require approximation or harmonization in the future with regard to our national legislation, including financial services, including services in general, use of electronic services, and so on and so forth. There have been some other initiatives in Kosovo. I'm not going into details on this. I'm just going to mention here, like the process of establishment of a special commercial court, which is supposed to improve the liability of business sector in the justice system, instead of having a special department that we already have within Basic Court of Pristina. It is supposed that the new court will improve the process of resolving disputes related to business sector, but also the issues related to business organization in the future. I mean, including the bankruptcy and related procedures. And the other initiative that has been only at the level of ideas, having a commercial code, which I think needs a careful discussion and analysis before we go deeper in this process. This is a short introduction about the topic I choose to discuss with you today. If you want further discussions, please feel free to join in discussions. Thank you.
Thank you very much. I think we will further the special points you underlined. I know even more in practice, could I say to you, can EU business law codification be a facilitator in private contracting?
Hi, everyone. First of all, thank you very much for making me a part of this endeavor. I'm very happy to be here and share my points of view from the practitioners' side. And I think if I can, I prepared like a PowerPoint presentation to assist you and follow along. I'm not sure if we can do a shared screen or not, but if you give me 1 second, can everyone see it or?
Yeah, perfect.
All right. So yeah, basically, whether codification of the EU business law would be a facilitator of private contracting, and because this falls within the purview of what I do basically on daily basis. So as I was thinking about preparing for today, I looked at it from or approached the issue from two points of view. One is from the contracting phase, in other words, getting to a final contract between two parties, in this case coming from two different countries, sometimes from within the EU, and in other cases, which is often my experience, from two countries that are either one from the EU and one non-member, or both of them being from outside the EU. And the other side of the medallion, or the other way to look at it, is the contract is over, but a dispute has arisen, and how the codification of EU law could help us in that regard. So with regard to the first one, this is basically a never-ending story, but I'll try to be as brief as I can. One of the major benefits is that it provides a common denominator between the parties. One of the toughest things that we get to negotiating contracts is choosing what is the applicable law pursuant to which a contract will be implemented. And in this case, that difficult kind of issue would be erased potentially if we have two parties from the EU. But even so, if we have a contract between an EU member, a business from the EU member state, and a non-EU member state that has harmonized this law with the EU code. Moreover, it would increase legal security for all businesses that operate in member states and beyond. And what's also very, very important, despite our best efforts as practitioners and drafters of contracts, regardless how long you make a contract, there's always things that are left out. And it's good to have clear or clearer filler principles in areas not covered within the four corners of the contract. What is more is also that it sets clear and understandable legal principles and criteria for all parties involved. In addition to that, we often, as we try to draft laws, local laws, be it law and business organizations or obligational relationships or whatever, we try to look for others that have perfected that specific area of law. For many years, we've been kind of looking toward the EU, even though we get a lot of influence from the US as well because of their presence here through the US Embassy and United States Agency for International Development. But nevertheless, by having a codified EU business law, it would provide us with a clear and unified example to follow as we try to harmonize our business laws and eventually maybe our own business code that was mentioned earlier for not just Kosovo, but any other country that aspires to join the EU. In addition to that, I think it would be much easier to compete as a business when the legal rules of business are uniform across the board. I know a lot of businesses from the EU trying to expand within the EU or even outside, but also we have a lot of Kosovo businesses trying to expand within the EU. And what happens is they encounter those difficult first stages of learning about the legal environment in that specific country where they're trying to push forward their products and engage in that expansion. So this is very, very important, having a legal environment which is familiar for a business trying to expand beyond its borders and beyond its current area of operation. So that's the one side in a very, very short and brief way. The second side of it is the dispute settlement. What happens if you do have a contract and you're trying to resolve a dispute between two businesses? And honestly, it's much easier to argue when the law is clear and uniform. It's so much easier when you have a law that everybody knows what it is, all parties know what it is, especially with regard to the courts. We mentioned earlier potentially a EU commercial court. We mentioned that there's a commercial court in the making in Kosovo. And what happens is whenever you have a clear legal basis, it's easier for the courts to implement those laws in resolving disputes. Now, what happens is we have certain laws in Kosovo that reference EU law, and it's so much easier for us. Like I had a case where I was served as an expert in a international arbitration case with regard to telecom and competition issues. And it was so much easier because our laws referenced EU law, and I could kind of pull out of the EU law to make sense of our provisions in the law and give an opinion on the matters that were at dispute at the international arbitration. And I think if we were to harmonize our business laws or even eventually our business code with an eventual EU codified business law, I think what happens is, for countries that are small and courts that lack the experience, like Kosovo, Macedonia, even Serbia, Bosnia, and other countries that aspire to become EU members, we can kind of piggyback on developed jurisprudence from other places that have more developed business law jurisprudence. So this would be very, very beneficial to us, especially in cases that are complex commercial cases that might not happen very frequently in our domestic courts, but you might get that 1 or 2 cases a year, and then the courts and also the practitioners could kind of draw on jurisprudence from the European Union and from the EU, eventually the EU code. Another issue that we've encountered is in international arbitration, where if you're in Vienna or Stockholm or London or whatever, and you find these exceptional and qualified arbitrators, but if the contract says that Kosovo law is applied, must be applied, or Albanian law or North Macedonian law, it's difficult to find very qualified arbitrators who also have knowledge. So you're dealing with additional expertises that need to be drawn into the arbitration proceedings in order to understand what the law is. Whereas this would be alleviated if we had a clear EU business law code and also our codes that are harmonized with that. Also, as I mentioned earlier, just the ability to use legal precedent in complex areas for local courts, jurisprudence, with courts that don't have the depth needed in order to resolve these difficult and sometimes not so common commercial cases that come across our courts. So what can we say about the steps forward? Well, I think it's important to push and promote the idea of codification of the EU business law, especially in key areas. Moreover, it would be important to continue efforts to develop an all-encompassing EU business law code, meaning as time passes, we kind of enhance and develop more and more newer and better and more in-depth versions of the EU business law code. And then also engage in harmonization, at the same time, engage in the harmonization of the local business laws in countries aspiring EU membership. Parallel to developing the code at the EU level, also working on the countries that are aspiring EU membership to harmonize their own domestic laws. And I think the EU has substantial power of persuasion, obviously, with most of these countries because of the amount of investment that they make in the process of EU accession. So the long story short, from a practitioner's point of view, is that it would make our lives a heck of a lot easier if there was a EU business law code, and then also domestic laws that are harmonized with that code. So thank you very much.
Thank you very much. Very useful. Thank you. I think we'll discuss a little bit more about the US Uniform Commercial Code. I think there's a point that's very interesting to know that a non-Latin state judicial order has its own uniform commercial code and not the European Union. That's funny or not. Well, but last but not least, let's get some high with Arjen Recha. Is Kosovo even ready with its approximation that your colleagues talked today about Kosovo legislation with the EU?
Hi everyone. First, I would like to thank Europa Nova and University of Pristina for bringing us together to discuss this aspiring project of scholars and practitioners on the codification of European business law. It's also a great pleasure for me to be here with among prominent panelists, all of them my professors during my studies, and share views on this ambitious project, and most important, discuss about the opportunities that this project presents to Western Balkan countries, specifically to Kosovo. The codification is yet an early initiative. Other speakers already addressed the views and the benefits that we will have in case of codification. I think that also one one great impact if this goes further and we end up with the codification of business law is that there will be an increased trade between member states, mainly because of the uniform approach that we'll have, and there will be common principles applied that can be easily understood from businesses in various jurisdictions and lawyers of these jurisdictions. The codification will also diminish the current discrepancies that are between various national laws, and will eventually lead to more clarity and more accessible law for us as lawyers, but also for businesses as well. Is it the right time to have it? I think it is a logical conclusion. If we have a common market, a common currency, it is just about the right time to have codification on business law. Obviously, there are challenges as they were discussed by previous speakers, and I will not go into that further. My presentation and the focus today is about the opportunities that the EU business law presents to Kosovo in particular, and whether we are ready in the approximation process of our legislation. As a country, almost now 13 years after declaring the independence, we face numbers of obstacles regarding recognition as a sovereign state. We are yet the only country in Western Balkan countries that do not have the freedom of travel to Schengen countries. Regardless that on few occasions the EU Commission has recommended the Parliament and the Council for visa liberalization for Kosovo citizens. Regardless of that, it is quite natural for us to aspire to join EU, and it's a top priority. Majority of population in Kosovo is also in favor of joining European Union, and this is something that is enshrined even in our declaration of independence. Also, politicians in Kosovo, they on their daily interviews, and they always claim that the only way forward is integration. However, I think we lack political will and commitment from the government to implement some fundamental reforms and achieve results in the area of rule of law, judiciary, fight against corruption, reforming public administration, etc., etc. As noted by other speakers, one of the areas where we have made significant progress is that of harmonizing or aligning the legislation with the EU acquis. Now it's a country strategy for more than a decade to harmonize the legislation with the European Union law, and we have made quite good progress on that. The Stabilization Association Agreement, which is the first contractual agreement between the Union and Kosovo, provides for a legal base for approximation, with a focus on the early stage on trade-related areas, justice and internal market areas. So now not only is a country strategy, but it's also a legal requirement deriving from this international agreement between the Union and Kosovo. Also, as a country, we have introduced internal mechanisms to ensure that future legislation, when adopted, complies with the EU acquis communautaire. For example, anytime there is a proposal for a draft law, or there is a draft law drafted, a prior confirmation from the previous inline ministry on European integration, now Office of Prime Minister, Department for EU Integration, is required to confirm that the proposed legislation complies with the respective directives of the EU. So even at parliamentary level, we have a commission on EU integration matters. As it was discussed by the other speakers as well, the business field area laws, legislation such as company law, which is mainly governed by law and business organization, competition law, including taxation, or overall in compliance with the EU acquis communautaire. We protect free competition. We prohibit abuse of dominant position and have restrictive rules we have rules against restrictive agreements between companies, including here in case of concentration between companies which might impede competition. Currently, there is a new law pending approval new law on competition, in fact, pending approval before the Assembly, which shall further align all legislation on competition matters with the EU acquis. Unfortunately, just like in many other sectors, we are not very good when it comes to interpreting and enforcing decision. For example, we lack enforcing decision of the competition authority. And what is worse is that from summer now, we don't have elected member of the commission authority because the mandate expired sometime this summer, somewhere in June. This is a chronic problem, I would say, that follows us as a country. Until recently, we didn't have members of the board of directors for a very important institutions such as Office of Regulatory Energy Office. Now we don't have member of the competition authority, and this, of course, impacts the functioning of the institutions. From tax perspective, we have. It is worth mentioning that in the recent years we have aligned legislation with the EU. Our VAT law is based entirely on EU VAT 6 directive, and is also harmonized with the legislation of EU member states on important key issues to facilitate trade in goods. The VAT law as well foresees that in case the interpretation should be in line with principles of European Union VAT system directives and the judgment of Court of Justice of the European Union. Additionally, the law on tax administration and procedures provides that where a local legislation do not address taxation of international transactions, they may be supplemented by the principles of the OECD Model Convention on Capital and Income. Overall, I would say that one of the successful part that when we are successful is that of aligning the legislation. Further alignment is required, but we are on the right directions. What I think what we need to improve immediately is enforcing the legislation, and interpretation must be by let's say our public institution, including courts here, must be in line with the principles of the respective EU directives. One thing I have witnessed over the course of my career is that there isn't too much regard given to EU directives from the institution, from the ministry who themselves proposed or pushed for the law. And even here for institutes that it's clear that they were not before here in our legislation, but it's clear that it's deriving as a result of approximation and harmonization process with EU acquis communautaire. And this is something that must change because we will risk of having very modern legislation, but which cannot be enforced in practice. And last but not the least, I think we need to increase judiciary capacities and have specialized judges that can adjudicate on complex cases on competition, taxation, commercial company law, etc. Unfortunately, until recently, we haven't witnessed that yet, and this is an area that we must improve. We must improve ourselves, because if we have modern legislation and interpret it not in line with the EU directives, and that is a problem that we'll face in the future. This is my presentation. I think I am the last one from the speakers, so I will pass the floor to colleagues in Paris, and I open also for any additional questions, should there be any.
Thank you very much. Maybe because we already have some questions from the public, I will give you a few minutes to organize your ideas, because he took a lot of notes. I think he's got a lot of things to tell us. Before, please, I will let you a few minutes. Between the questions we received, first question for maybe for the academics, if I could say that. Does the failure of past codification efforts in the field of civil law influence the willingness for the new aspired codification on business law fields?
Okay, maybe because
Probably.
wait.
Okay.
I'm trying to, I would, maybe this is a question that might be better answered by Professor Cherkin Berisha, because he was part of the working group on the civil code. But just to add that, as myself, I don't see the civil code as a failure, because it's still, as I said, under review, and we are trying to really be careful with that, because civil code and codification of any particular area, it's not something that must be done in a rush, but it must be really carefully considered. So it will be the same for other codifications as well. And of course, Kosovo is a country that has been going through quite a number of transformations, starting from post-war, and then with a with declaring the independence. So we had like a number of laws that have been applied and that have been substituted by other laws passed by the Kosovo Parliament, substituting the laws of the United Nations mission in Kosovo, and so on. So codification process is not an easy process, but it's not easy, but it's definitely not a failed process. So Professor Berisha will maybe.
Yes. Okay. When I mentioned the process of drafting civil code, I never said that it failed, but I wanted to say that the process of codification is very complex and requires a lot of efforts, even though we already had very good laws recently drafted, like law on property drafted in 2009, law on family 2005, for example, law on inheritance 2005, and obligations 2012. So it means that even though the legislation was recently drafted, the process of codification of this legislation still show to be a very complex issue, because you need a lot of expertise. First of all, you want to keep the tradition. You don't want to draft something which is completely new, because then it will be very difficult for judges, lawyers, and everyone to implement it. And when you draft civil codes as well, you have to decide about some well-known models. For example, which model of codification you will follow. Of course, we are a country in Europe, and we will follow some of the examples from European civil codes, like German civil code, for example. But we have at the same time to keep as much as possible from our tradition of legislation. And I mentioned as a challenge as well the process under which the idea of having a European Civil Code faced during this 50 years. From 70s, when the idea of Lando Commission on codification of European civil law started till now, what the European Union ended up was draft common frame of reference, and of course, I'm not trying to say that it was not important, because as a soft law, it can be applied and it can be used in contractual relations between parties, but it was a very challenging process, and I wanted to say that the area of business law may face similar challenges, taking into consideration divergences between national legislation of European Union member countries. Of course, those who will work in the process of codification of the business law in European Union should take into account all these challenges from the past examples of codification of other fields of the law, like civil law. Of course, there are differences because civil law, to some extent, I mean, a large part of civil law, to some extent, is internal issue of member countries, while the business law is more on the European Union side in terms of competences, and in this sense, it may be more successful as an initiative for codification, comparing to area of civil law, for example, like property law or inheritance or any other fields, apart from obligations, which Professor Seydiu mentioned, and I think that is one of the contract law and obligations may be one of the areas that may be potentially more successful. Thanks for.
Very enlightening. Thank you very much. A second question for our practitioners today. Corona epidemic has created an economic crisis, which leads in a change of reality in which the EU will need to adopt. In your opinion, will this have an impact to the member states and the companies of the EU member states to show more readiness and work together more seriously on the code?
Well, I think COVID has at least taught us how to use the mute button on these online conferences, because we start speaking and then we realize that we're on mute. And I think that's a pretty good prelude to the fact that, yes, I think COVID and everything surrounding COVID has, especially with supply chain disruptions that we've seen recently across the world, but especially in the EU and the United States, have required us to be more adaptive and also to collaborate a bit closer to one another. And going back to my final slide, which said it would make our life easier, I think it ties to the fact that if the business law would elevate from the EU member state level to the EU level and provide a clear guidance, I think it would be much easier for not only EU member states, companies from EU member states to contract with one another. But I think even for us looking from the outside in, either as aspiring EU states or even say companies from the US, from Asia and so on, it would be much easier for them to have the other side coming in with a body of law that's codified and it's clear and it does not deviate depending on whether it's Germany or France or some other country. And this goes to even further with the sheer fact that many of the companies that we deal with are no longer a German company or a French company because they're operating all over the world. And sometimes it gets very complex understanding what laws would be applicable if something went awry, or even, when you're trying to do simple things like arranging for transport or, getting insurance and so on. So my short answer is yes. I think it would definitely go toward helping in this regard.
Mr. Rachel, maybe some other points.
Was that directed to me? I'm sorry, I couldn't hear you.
I asked Ardien Recha if he had something more to add about this.
Sorry, I didn't understand. I was confused, sorry. No, totally agree with the Professor Korab, and there isn't anything else that I want to add related to this question.
Okay, thank you very much. Maybe more question for you. Would the new rules simply replace the domestic business law of the member states and aspiring states, or would they exclusively govern intra-community relations? What do you think? What would be the best?
So who wants to start? Maybe from
Again, thank you.
practitioner's point of view, or given the the fragmentation of the laws and the idea of the codification. Of course, the idea of codification does not entail that all the rules should be replaced, because there are still good rules to be kept, and new rules needs to be introduced in order to simplify the lives of citizens and also of doing business in an internal market. When it comes to the Western Balkan countries, unless we for as long as we are a country aspiring the European Union, of course, we can never replace all the rules with the newly codified EU legislation, because even now, in the process of harmonization of our national legislation, if we look at the certain provisions of the different pieces of legislation that have been harmonized, they have been harmonized only to some extent. Because there are always rules that are exclusive for member states. So, and we cannot reach full harmonization until we don't become members of the European Union. So, I don't know if Professor Cerchini would like to add something or something from the practical point of view. But the codification should be just a code bringing together the best rules that there exist. So I don't believe that now I don't want to go into details, and it's a matter of a deeper research to see what rules are there to be kept and what rules are there to be replaced. Professor Berisha?
Well, first of all, any process of codification doesn't mean that you will draft or prepare something completely new. In this regard, we have several European Union directives. I think the process should, first of all, should start with compilation of what already exists in terms of European Union legislation, and only then further analysis should be done whether the existing existing legislation in terms of directives and other instruments should be amended in order to improve the existing legislation. This is one side, and the second side, its applications towards towards member countries and aspiring countries. Well, it depends from the instrument and from the form and the way how the European Union intends, or how it is supposed to be implemented in the future. Because if we have instruments such as directives, more or less, we can say that it is difficult to apply and to apply in the same manner towards the entire member countries of the European Union. And the practice so far was that the instruments and the form of harmonization was left towards member countries. But still, I mean, it depends. It depends from the approach that European Union will follow in this case.
I think in this case, it would depend on the consensus you would build and what
Exactly.
are the states willing to give up as part of their giving up portions of their sovereignty to the union. And I think some states are going to be very protective of some areas like corporate law, because if you look at it, some of them, that's what their kind of comparative advantage. But I mean, there's different ways to look at it. I mean, it could be looked at as a replacement of domestic laws, but it also could be looked at as an alternative, which parties could elect to make part of their business transactions. I'm talking about private parties, something similar to the UN Convention, for instance, the Vienna Convention, UN Convention on International Sale of Goods, where parties can adopt it wholesale or bits and pieces of it, depending what their what the will of the parties is. So I think there's different ways of looking at it, but in my personal opinion, I think it's good to have a clear legal basis, thereby choosing what do you want to elevate to the union level, and then just replace the domestic law with it.
Yeah, I also agree with the previous speakers. We cannot. I don't think it's. They will, in the end, it will end up in eliminating all domestic rules. But what is important is that to have some key core principles set in EU level, and which can be applied in uniform manner. This will set some, at least, key standards or minimum requirements that each member states must follow. And as discussed, it's difficult because of the not all areas of the business law or let's say an exclusive competence of the EU Commission. For example, on competition matters, maybe it's quite easy to have something in totally unified and the same rule because it's an exclusive competence of the Commission. But taxation, then it's a shared competence between member states and the union. So it's a bit difficult then to entirely replace the domestic legislation of the member countries.
What a brilliant transition to the next question. Do you think that the rules in business law code would have to be mandatory or optional as kind of toolbox left at the free disposal of the parties?
Do you want me again to speak first? Looking at the business law, the law on Kosovo law on business organizations, we see that most of the rules are are not mandatory. Only when it comes to maybe joint stock companies that has more rigid rules and more mandatory rules. All other forms of businesses are really based on the principle of the will of the parties. So they can deviate from these rules, and they can foresee something which suits their legal relationship better. So as I said before, business law is quite a dynamic and fluid area. So I mean, maybe to give more flexibility to businesses, and it all depends from the model of the European company that would be proposed in a codified business law, because the question to that answer really depends on that as well. But the business law itself is based on the principles of the party autonomy, and that entails automatically that most of the rules should not be mandatory. So maybe my colleagues disagree with me, and
No, in principle I agree, but it depends what kind of issues are mandatory and which are how to say on the will of the companies. But for example, European Union can decide which forms of business organization are recognized under the European Union, which is one of the key issues, for example, discussed in this area. For example, we have social enterprises registered in most of the European Union countries as NGOs, and the question quite often is raised: should they be registered always as businesses, even though they are not a profitable form of businesses? So it depends from the issues. But if we discuss about the way how businesses are have chosen to be organized, definitely is on their side. So we cannot force them. Of course, the part of business law has some rules which define the role of public authorities as well. In that sense, okay, I think it can be fully harmonized, but in the part of businesses, no, I fully agree with Professor Rulieva. I don't know what other colleagues think about this issue.
Well, I agree also with colleagues, but I would say that in cases when there is transactions between businesses in from two or more member states of the Union, then it's quite easy for everyone to have the EU business law being applied, or the core minimum requirements that eventually will be incorporated in business law. So in such cases, I think it can be, let's say, mandatory applying the governing legislation of the transaction to be the European business law. In other cases, then it's the domestic legislation applicable. So probably in these cases they shouldn't be applying, or the domestic legislation of the specific country will be the governing legislation of the specific contractual agreement between parties.
So said you, maybe something more?
I think I already mentioned and went through this in my prior answer, where I said, it's different ways of looking at it. It just depends on what the EU member states want to give up as far as their regulation of the business community goes. So it just depends on and it's as the EU gets bigger, it gets more difficult to agree on issues as we've seen in many other issues. So I think business organizations is a key area to agree on, and probably the most difficult one to agree on, just because they regulate in different ways depending on what their approach is. You have some countries within the EU that have a more social and more employee kind of targeted or approach, whereas others might be more capitalistic in a way, and it might be difficult to harmonize those ideas by elevating everything up to the EU level.
Excuse me, but it also will depend on the influence. What will push our companies to not only the member states. I mean, we have our governments, we have our member of parliament, but what about the companies? How could they push it? Because what you explained today is that it's their own interest, clearly. Do you have any comment about that?
Well, I think the companies have, especially large companies, have significant amount of persuasive power, and their lobbying efforts are often quite powerful in getting their agendas through. And I think it's important to work with them to get that power behind this idea, to push it forward. Now, there is a type of company that can be registered at the European level, the SE, the Societae Europaea, which hasn't really taken off as much as everyone thought that it would, because maybe there really isn't enough, support behind that idea. But I think if you get the major European companies pushing toward unification or codification of the European business law, and I think you touched on the fact that COVID has made us realize how small the world is and how we need to create more uniform rules with regard to how businesses operate, not just within the EU but abroad as well. And just get them to understand that it'll be easier for their business as well, in cooperation with other businesses outside the EU, for the outsiders to understand what they're dealing with. So I think if we can get those big businesses to support this idea, then it will be much easier to also persuade the political side of it.
Thank you very much. Mr. Bayram, ready to close the discussion?
Very good. Okay. So, thank you very much. It was really a pleasure to witness this close collaboration between Europa Nova and the law school, the University of Pristina, the university where I finished my basic law studies. It was really a pleasure to see also some familiar faces from where it makes me feel like almost home. I was very happy to be part of this audience and listen to this discussion, which is very important, with a very important topic for me as a former practicing lawyer. As a former practicing lawyer, I was always fan of this idea of the unification of the law. Even beyond this, unification makes some kind of global law. But there was some more experienced lawyer that came to me and said, "No, this is all wrong, because then we will lose our jobs." So, yeah. Now, since the very beginning, the idea of unification and harmonization of laws, it sounded maybe very utopic, but here we are. So the circumstances change, the reality is different, and this is not a dream anymore, but it's a reality. Maybe we are halfway now, but we somewhere on the horizon we see that we're approaching. So many important opinions and topics has been already discussed by the scholars, academics from the law school in Pristina and from very distinguished practicing lawyers in Pristina as well. So I don't have, so my opinions maybe would be redundant on this regards because I'm not a lawyer anymore. So I changed my field. But as a representative of my government in Paris, in one of the EU epicenters, I can only confirm that Kosovo has already made many steps, many important steps towards the unification and harmonization of its laws with the common European legal framework. Most of this was initiated unilaterally as a gesture or as a token of goodwill of approaching with EU values, etc. The course in Kosovo has recently, especially the last decade, they started to apply and started to mention in their judgments and in their decisions the EU case law, which is a very big step forward. And also the lawyers, when they do their pleas, they have some backups from the EU law standards. In addition to this, in addition to these steps forward, we have also several alternative dispute settlement centers in Kosovo. We have arbitration tribunals that are capable of settling differences between the parties. As my colleagues mentioned there is also a special commercial court that is going to start this court very soon. Of course, there are things that still has to be done, but we are in a good. We are following the good law. But what is most important for me as a representative of the embassy here, to assure you, to confirm that the economic development of Kosovo remains one of the most important priorities of the government. And by this I mean exchange of the goods, exchange of services, especially exchange between Kosovo and EU countries. And when I'm saying EU countries, when I'm mentioning them, is because that European Union always, it remains the most important economic partner and the most important investor in Kosovo. So such a harmonization of Kosovo domestic laws with common European legal framework, it's a very important for us. So these kind of discussions between academics from Kosovo and from the rest of Europe are very welcome and very fruitful. So this is all I have to say to salute you for the organization of this event, and I was very happy to be part of this and to serve. Thank you very much.
Thank you very much. To close quickly the discussion, I think that the main idea of this meeting was that Enlargement as a European business code are projects providing a new dynamic and give meaning for our future, for our European future, because it mobilizes an extremely wide spectrum, they both mobilize civil society's components. We are currently mobilizing trade unions, companies, small companies. We talked about it. I mean, all of them, all of us who are directly concerned by the future of Europe, and in other words, creation of wealth, creation of employment, and enforcing the situation of our students, of our young people, those who are the first one concerned by the future of Europe. In both projects, enlargement and establishing a unification of the business law code, the idea is to place corporate, commercial, labor relations at the heart of the revitalization of the European project. And that's why I certainly think that both projects are totally linked. And I think the message today was absolutely clear too. So thank you very much. Sorry for my very tired voice tonight. Thank you to all of our speakers. Thank you to the public. Thank you to Fiola Ibrahimi, who organized it really brilliantly. And please have a nice evening. And I really hope see you soon. Thank you very much.
Thank you.
Thank you very much. Bye-bye, everyone.
Thank you very much. It was a pleasure. Bye-bye.
Thank you very much. Have a good night.
Thank you. Good night.
Thank you. Thank you.
Yes.
And until our next meeting. Bye.